Court of Appeals will convene again today to hear more about whether they should intervene. Meanwhile, Griffin's ballot challenge will be heard next week in a court in Wake County. That was sent back to that court by the state Supreme Court last week.
Joining us now, our chief legal analyst, Khalif Rhodes. And if it seems confusing at home, don't worry, it is confusing. Even the judges were saying, okay, so the state Supreme Court, they dismissed the attempt to have it heard at the state Supreme Court. They tossed it back, and the circuit court judge says, what do we do with it?
If you seem like this is confusing, you are not alone. I am confused and I live in this world. I can tell you there's a couple different things happening. You have the original contest of election, 734 votes versus 60,000 votes. Who knows what's going on there? So you put that in the hearing, and you have to determine, can I determine if these folks, or can I prove that these ballots should not be counted? In addition to that, we're determining, is it in the proper venue? Is this the right place for this case to be heard? And so the original case was being heard on the U.S. District Court level. U.S. District Court level determined that, listen, this case is not the proper venue because this is a state issue, not a federal issue. And I do take a little issue with that, and I'll circle back to that. So he punched it to the Supreme Court. Supreme Court hears it, and they're like, well, you know what? We don't know if we should really hear this case. We're not going to give you that probationary period. We'll allow the state not to certify it. We'll hold that certification process off, but we're not going to hear it. We think that a trial level court needs to hear it, and they said a local level trial court. So then what does that mean? That it should be going to a Wake Court County. That's what you would think. But wait, now we have this appeal process happening where we're going to send it to the U.S. Court of Appeals. There's so many moving parts here. I can tell you that you'll need multiple legal scholars, not just me, who attempts to play a legal scholar on TV to break this down. At the very minimum, it is confusing, but I can tell you when it boils down to it, I think the original judge that heard it, that U.S. District Court judge, I think he erred. Courts, I should say, the federal process dictates what happens with election processes. And so it should have superseded there. I think that's why we're having this reluctancy. That's why I think the U.S. Court of Appeals wants to step in, but really can't, because the Supreme Court's kind of already made and already kind of put their teeth in it just a little bit. Took a little nibble, didn't really do a bite, and that was the problem.
I feel like you need X's and O's, like a football play. This is all over the place. How long is this going to go on? I mean, that seat has got to be filled.
It's giving Bush v. Gore, right? It's like, okay, do we not have an election? Do we not know who the president is? It also is confusing because Riggs, who sits on the Supreme Court, had to recuse herself because why? This case went to the very court that she's trying to get back onto that she currently sits on now. I think it can go on for as long as they have enough resources to allow it to go on. And when I say they, you have a lot of moving parts. You have the Board of Elections. You have Riggs. You have Griffin. You have a lot of parts. You have the state GOP that wants to intervene and attempt to be heard on all these matters. It can go on as long as the court drags its feet. I think these oral arguments will probably end today. You'll hear the arguments, and I think this court will say that at the very minimum, the U.S. District Court, they'll kick it back to them to be able to hear it. So we'll have two of the highest courts, our state Supreme Court kicking it back to the lower court, our Court of Appeals on the federal side kicking it back to a lower trial court, which would be a U.S. District Court. At some point, a trial court will have to make a determination before we can get to where we're at.
Real quick, you broke down the legalese. I want your analysis now. The longer this goes, what does this do in terms of looking at the integrity of an election?
Well, I think it goes to undermine the integrity process. I mean, what Griffin is saying is that there were 60,000 folks that should not have been counted. I think the Board of Elections has secured and assured voters that there was no irregularities there. So it does undermine the trust and the concern that there are some irregularities, even if there are none. They're saying that the other side saying we won by 734 votes. This election should have been over with. I think if the Board of Elections continues to say we did everything we were supposed to do, that even if those folks didn't have a driver's license number, if they didn't put their social security number down, they would have got a unique number. They would have been able to vote. And when they came to vote, they would have had to show their ID, because you guys passed voter ID before this election anyway. So I think all of the things were done that were supposed to be done to protect the integrity. I just now hope the court goes and reaffirms that.
We got a lot of legal things to talk about with you this morning. We're keeping them around till at least 9:30. So Khalif will have you again soon. Thanks.